The Judicial Service Commission yesterday started interviewing candidates for the Constitutional Court. Now, 2 posts have to be filled. 5 of the country's top jurists are vying for the post. Senior legal researcher at the Helen Suzman Foundation, Chelsea Ramsden, joins us now to discuss this. Good morning and thank you very much for your time, Chelsea. A very interesting day, I must say, at the JSC interviews yesterday. Now, perhaps to start with the criteria. Much was made of it, but upon perusal, it looked pretty basic to me. Are you qualified? Are you fit and proper? Do you have the technical expertise? However, the Commissioner's line of questioning suggests they're looking for more than that. Your jurisprudential philosophy, perhaps, your attitude towards the Constitution being used to further the transformational agenda and stuff such as those. What do you honestly make, though, of the criteria in comparison to the questioning?
Hi, good morning, and thanks for having me on. So the criteria which we've been complaining about for quite a long time has been, it's very broad, it's very open to interpretation by different commissioners and individuals, the candidates, the public. I see that the JSC have decided to use their 2010 criteria, which has been around, but in previous interviews there's never been mentioned, so we never know if they have been making use of it. In terms of the questions, though, I think because the criteria is worded so broadly, you could link it in some way or another. And I think they tried to make a very big point of doing this by beginning each question with the preface of the criteria says this, this, and this. What do you think? Or something along those lines.
Yes, they made a big issue of it yesterday, which actually prompted me to go and look at the criteria. But still, like you say, it's open to interpretation and several interpretations. So it's quite broad and honestly perhaps needs to be realigned to even perhaps speak to the transformational agenda that they speak of quite often when they question some of these candidates, because there's nothing that really speaks to transformation when I looked at the criteria.
No, I think probably the closest criteria that could maybe be used for this would be how it would be viewed by the public at large, how the appointment would be viewed at the public at large, or their commitment to constitutional values.
Yes, and the demographics so that speak to race and gender. Then to the candidates, I must say it really saddens me when questions or matters arising from a single candidate's interview then become or sort of overshadow the other candidates. If we had to look at David Unterholter, before we get to his exclusion, maybe the debate around the exclusion, whether that specific error that we heard of warrants an exclusion, can we just start with the court process here? When we speak of the SCA or the ConCourt, if a matter comes before the ConCourt, one assumes that it's not something that is just brought before them or the bench. They would then have the SCA judgment before them and they would go through it. So in this instance, what could have possibly happened? Because when we look at the first page of a judgment from the Supreme Court of Appeal, it would have the quorum in it, and then it would tell you who sat on the bench. Even us journalists would know how to at least work around the first page. So what could have possibly happened in that respect?
Well, in this instance, there was no judgment from the SCA, but merely an order, and Judge Unterholter explained that this was attached on the last page of the application. So that order should reflect his name, and I believe it did. But there are numerous applications received at the constitutional courts, and at any given time, one judge is responsible for that matter. They would draft a memo, circulate it around, and that would allow for the other judges to either concur or dissent against it. Obviously, having read the papers and that, but in such instances, I think these small errors can actually happen, and this was recognized by the Chief Justice, and he's planning to implement changes so that this doesn't occur in the future again.
So you say that it's an error made by the judges or justices on the day on the bench, not something that should be attributed to him alone.
Well, I mean, it was his name that he did not pick up, but there are many processes that go on before that. Clerks are involved. I've worked at the constitutional courts. If they didn't pick it up, he didn't pick it up. It must seriously just have been an oversight. The quorum was reached without his name on it, so as I can understand why to the public it would appear to be it could appear to be a problem, or that to create this distrust. However, the matter would have still been exactly the same outcome, whether he had or had not been on it. There's no public hearing for these matters especially if it's dismissed. It's just a chain of emails that go around. And as I say, the workload, which was recognized by Judge Rogers in his interview, is intense. He's never been subjected to such a workload before, and he's been a judge for many, many years. Unfortunately, as I said, the error did occur, but he took responsibility for it.
So do you think perhaps for ordinary citizens who might not have an appreciation of the workload, they would then unfairly criticize and say if the matter came before him at the SCA, even if the documentation before them was not there, but he would remember that he sat on this matter as they're going through the merits of the case, he would be somebody that remembers. Do you think that is unfair of some to assume that with all the cases that you sit on, you would remember?
I do understand why that would be the public perception, or at least parts of the public perception, and that was definitely played on by some of the commissioners. But it is the case where there are just so many matters that come before the judges, and that I know that they've looked into doing various things. And since the jurisdiction has been increased, it's just there's quite a lot. Things don't happen quickly all the time between the ACA and the Constitutional Court. There's often applications for condemnation. And as I said, these are matters that are just read on the papers. There's been no hearing, so there's they don't stand out like those that have been heard, if I could say it that way.
No, thanks for that clarity. Then on his candidacy, I mean, he's somebody that's fairly new in the High Court. I think he was appointed around 2018. But among his colleagues in his years as an advocate, clearly a respected legal mind in the fraternity. I mean, colleagues often say that, you know, if he's your opponent, he gives you a run for your money, even as journalists, when you watch. I mean, they're advancing cogent legal arguments. It's beautiful to watch the law as they argue it with opponents. So one then wonders, at least one would want to know your view, would that particular error, grave as it is, warrant his exclusion?
Well, the commissioners vote in secret. I mean, they require a majority vote. So there was obviously enough commissioners that felt that this is an error that was large enough. However, in the previous 2 times, he's also not been nominated. So I believe it'll probably be something that goes above and beyond this error that was just noticed. At the end of the day, it is up to the JSC to appoint them, not to appoint, that's the president's job. It is the JSC's to recommend. I personally, and this would not be I don't know the view of the HSF, but personally, I don't believe that that is an error enough to exclude him. There must be other reasons for it. And then, unfortunately, we have run out of time, but I do want to touch on just a few of the other candidates. So unfortunate that we have issues that overshadow other candidates, at least how they progressed yesterday. But first candidate, we had Advocate Helen Dotson. How did you find his interview, particularly his response to Commissioner Malema when he was asked around what elements of transformation does his appointment advance, being race or gender? And then he went on to say, I'm an African. Well, Advocate Dodson he always interviews well. He is quite quick in answering his questions, and they provide good detail that would be able JSC commissioners to assess his suitability for candidacy. In terms of his transformation answer, I mean, they face these questions every time. I think they try at least come up with. It's not easy. I can imagine being in their position as a white male to say that I push any kind of transformative agenda. However, in the spirit of unity and recognizing that everyone has a place in South Africa, I don't think it is entirely unfair for someone to recognize themselves as at least, as African or South African. It doesn't designate an actual race.
But then numerically now, if we look at it, like he said, that then he would be in a far better position because at this point there is no white male at the ConCourt.
Well, the section requiring that the gender and race is represented in the judiciary doesn't require, it's not a quota system. So this doesn't mean that at any given time there has to be a set number or an even number. And these are things that are fluid and will move. So yes, he has a point. There is no white candidate on the bench at the constitutional bench at the moment. And it would be unfortunate if there was not going to be for a while to come. However, there are quite a few vacancies open. And these are some things that the president's going to need to take into account to see what is going to be the best appointment and what would help the judiciary the most. I do think having the best legal minds on the judiciary will be the best outcome.
No, thank you very much, Chelsea. A very interesting interview. I wish we had more time to discuss the other candidates, but hopefully one of my colleagues will touch on the others. That was Senior Legal Researcher at the Helen Suzman Foundation, Chelsea Ramsden.